This is terrific. We have basically a full house, which is very exciting. Welcome to Stanford Law School. I'm Michelle Dauber, and together with Fatima Goss-Graves from the National Women's Law Center and our steering committee for this conference, The Way Forward, Title IX in the Trump Era. We are very excited to welcome all of you here to this lecture by author Jon Krakauer, as I said, author of many, many excellent books, including most recently Missoula about the University of Montana sexual assault case. So without any more introduction, I want to welcome Jon.
I want to begin by noting that I learned most of what I know about Title IX and sexual violence by studying books, studies, articles, screeds, reports, and white papers written by many of you who are attending today. So I want to say thank you for that, and also don't expect me to be telling you anything you don't already know. One of the things you already know is that the population most at risk from sexual predators is women between the ages of 16 and 24. Many of these young women are in college when they're victimized, and it's during the initial days and weeks of a student's freshman year that she's in the greatest danger. Colleges and universities have a moral obligation to protect these highly vulnerable students from sexual predators. Most schools have a statutory obligation to provide such protection as well, thanks to Title IX. As a mechanism for compelling schools to actually meet this obligation, Title IX is far from perfect. But part of the reason Title IX isn't as effective as it might be is that it's misconstrued so often. This failure to acknowledge what the statute actually decrees has unleashed a fog of unfounded criticism. Surprisingly, or maybe not, some of the harshest criticism has come from lawyers and professors of law who insist that rape is way too serious an offense to be under the purview of university administrators. These critics demand that universities stop adjudicating sexual violence complaints altogether and instead require campus rape survivors to seek justice through the criminal justice system. Title IX detractors are especially agitated about the Dear Colleague letter issued by the Department of Education's Office of Civil Rights in 2011, which describes steps universities should take to improve their response to sexual violence. Among the instructions many lawyers find so upsetting is a directive to minimize the role of lawyers in sexual assault proceedings. Attorneys for the accused are instructed not to cross-examine the alleged victim or raise objections or even speak during a university tribunal. Trial lawyers are trained to be zealous advocates for their clients, and they consider oral persuasion to be a crucial part of that advocacy. Remaining silent runs counter to all their instincts. It's not how they are accustomed to doing battle at a criminal trial. Critics of the Dear Colleague letter are also up in arms because it requires universities to use a preponderance of the evidence as the burden of proof for adjudicating sexual assault complaints. They argue that because rape is such a heinous crime and because to be found guilty of rape can face such a shameful stigma, the burden of proof for campus disciplinary proceedings should be the same as for criminal trials, beyond a reasonable doubt, which is a much higher bar to clear. But a campus disciplinary proceeding under Title IX is not a criminal trial, nor is it supposed to resemble one. Furthermore, the government's policy of using the preponderance standard for campus sexual assault complaints was firmly in place long before the Dear Colleague letter ever saw the light of day. Contrary to all the shade thrown on Title IX by its detractors, the guidance provided by the Office of Civil Rights in the Dear Colleague letter is entirely consistent with long-standing legal doctrine. A student who has been raped is likely to suffer devastating harm on many levels. The rapist violates the most intimate parts of her body and wreaks havoc with her ability to trust. Rape inflicts a uniquely destructive variety of trauma that often persists for decades, and in the near term can make it impossible for the individual who's been victimized to remain in school. It thereby qualifies as an act of gender discrimination under Title IX, making rape a violation of civil rights law, in addition to everything else. This is what most critics of the statute apparently fail to grasp, that Title IX requires schools to respond to sexual assault as a violation of a student's civil rights rather than a criminal offense. And the burden of proof applied to civil rights cases, as everyone in this room knows, has always been a preponderance of the evidence. Indeed, the preponderance standard is the default in almost all civil actions, even those involving murder and other violent crimes. Of particular note, the preponderance of the evidence has always been the burden of proof when male students expelled for sexual violence sue their schools under Title IX, alleging reverse gender discrimination. It would be outrageous to allow men who claim they've been unfairly disciplined to win reverse discrimination claims using the preponderance standard, but require female accusers to prove they were victimized with a more stringent burden of proof. What's good for the gander should be good for the goose. The adjudication of campus rape as a civil rights violation doesn't change the fact that it's also a horrific crime. A Title IX grievance is not meant to take the place of criminal prosecution as a remedy for campus rape, and it doesn't preclude student rape survivors from seeking criminal charges against their assailants. Survivors, in fact, are often encouraged to go to the police in addition to seeking justice through a campus proceeding. But the criminal avenue is a much rougher road for a survivor to travel down than the path provided by Title IX. Criminal proceedings for acts of sexual violence require a vastly higher burden of proof than campus proceedings for the simple reason that a criminal verdict can deprive the offender of his freedom, while the harshest penalty a university can inflict is expulsion. This is a crucial difference. The high burden of proof is one of several significant procedural advantages that are granted to the accused in criminal proceedings in order to diminish the chance that an innocent man will be unjustly incarcerated. Excuse me for a minute. Such safeguards are to be commended in a democratic society. As William Blackstone famously pronounced in the 18th century, better that 10 guilty persons escape than one innocent party suffer. Unfortunately, for 21st century rape survivors who seek redress in the criminal justice system, however, Blackstone's 10-to-1 ratio doesn't accurately describe how many guilty persons escape when the crime is sexual violence. In the actual world we live in today, and this is not an exaggeration, it's likely that more than 1,000 sex offenders elude accountability for every innocent man who is wrongly imprisoned. I've done the math, that's not far off, it might be low. The intensely adversarial design of our criminal justice system, along with the protections it grants to defendants, makes it exceedingly unfriendly to rape survivors. At a criminal trial, legal procedure is given priority over the truth. Trials degenerate into clashes that resemble verbal cage fights, characterized by wildly exaggerated claims, highly selective presentation of the facts, and brutal interrogation of witnesses. Trial lawyers push ethical boundaries as far as they can on behalf of their clients, behaving in ways that would be considered morally reprehensible outside of a courtroom. The excessive partisanship becomes especially harmful when the crime being adjudicated is sexual violence. Criminal trials typically pit the state against an individual citizen. The advantages given to the accused are meant to level the field of battle as the lone citizen confronts the immensely more powerful state. But sexual violence cases seldom fit this model, because defense attorneys almost always transform the trial into a relentless attack on the rape victim's character. The victim is forced to play the role of defendant, but without the constitutional protections or procedural advantages enjoyed by the actual defendant. It's a ruthless tactic that has proven to be extremely effective, which of course is why defense lawyers rely on it so frequently. The toll this strategy takes on victims is horrific. As Harvard psychiatrist Judith Lewis Herman explains, involvement in legal proceedings constitutes a significant emotional stress for even the most robust citizen. For victims of violent crime who may suffer from psychological trauma as a result of their victimization, involvement in the justice system may compound the original injury. Indeed, if one set out to intentionally to design a system for provoking symptoms of post-traumatic stress disorder, it might look very much like a court of law. The mental health needs of crime victims are often diametrically opposed to the requirements of legal proceedings. Victims need social acknowledgement and support. The court requires them to endure a public challenge to their credibility. Victims need to establish a sense of power and control over their lives. The court requires them to submit to a complex set of rules and procedures that they may not understand and over which they have no control. Victims need an opportunity to tell their stories in their own way in a setting of their choice. The court requires them to respond to a set of yes or no questions that break down any personal attempt to construct a coherent and meaningful narrative. Victims often need to control or limit their exposure to specific reminders of the trauma. The court requires them to relive the experience by directly confronting the perpetrator. That's all from part of Dr. Herman's wonderful book, Trauma and Recovery. Given the degree to which the criminal justice system re-traumatizes rape survivors, it's no big mystery why more than 80% of sexual assault victims never report to the police. Between the staggering number of rapes that go unreported and the formidable procedural obstacles that must be overcome to obtain a conviction, the number of victims who find justice through the criminal justice system is vanishingly small. The most reliable research suggests that less than 5% of rapes are ever referred for prosecution, and less than 3% culminate in a conviction that includes any time in prison. When someone is raped in this country, the rapist gets away with it well over 90% of the time. If such alarming numbers were true for any other serious crime, conservative commentators would be excoriating political leaders and denouncing public policy, demanding immediate action to address the crisis. When the crime is rape, however, the pundits declare that the numbers shouldn't be believed. Women habitually lie about rape, they insist. Sexual assault numbers, they claim, have been wildly exaggerated in order to foster rape hysteria as part of a liberal political agenda. Although solid, peer-reviewed studies indicate that only 2% to 10% of rape allegations are false, the bogus claim that women usually lie about rape still gets a lot of traction. This came into sharp focus just last month during a rape trial in Memphis, Tennessee. The defendant was a 51-year-old tech millionaire named Mark Giannini, who had been charged with raping 3 women over a period of 13 years and was also charged for trying to bribe a witness. The alleged victim in the April trial was a 24-year-old woman who'd been summoned to Giannini's gated mansion to be interviewed for a housekeeping job. After she arrived, according to the victim, Giannini gave her a drink of an undisclosed liquid, began kissing her aggressively, and forced her to engage in multiple sexual acts. At one point, she testified, he put her hands around her throat and she blacked out. When she woke up, she was in the hospital. The victim said she made it clear to Giannini that she did not want to have sex with him. He said the sex was consensual. During the trial's closing arguments, his lawyer, a guy named Steve Faries, urged the jury to believe Giannini instead of the victim. People can be very good at lying, Faries pointed out. Women can be especially good at it, he added, because they're the weaker sex. A day later, the jury found Giannini not guilty. This verdict, which came down just 10 days ago, is yet another reminder that rape is the only crime where it's the victim who is presumed to be lying. I guess the point of this discouraging story is that here we are, yet again, debating how often women make false allegations about being raped, which raises an obvious question. Why doesn't the discussion ever seem to be about how often men make false allegations that sex being consensual? What's up with that? I've never seen a peer-reviewed study that addresses this question, but based on numerous rape cases that I've personally researched in depth, I would estimate that 90, maybe 95% of men who are found to have committed sexual assault lied about it. They lied to their families, they lied to their friends, they lied on social media, they lied to their court-ordered therapists, they lied under oath on the witness stand. Even after being confronted with undeniable proof of their culpability and then accepting a guilty plea in return for a light sentence, a shocking number of these rapists continue to tell anyone who listened that the sex was consensual and the victim lied. Because, hey, everyone knows that women lie. That's what they do. But you don't have to accept my observations about the credibility of male defendants, which admittedly are based on a relatively small sample size. Consider instead what the famous defense counselor and Harvard law professor Alan Dershowitz has observed over a lifetime of representing all manner of perpetrators. In his book, The Best Defense, Dershowitz writes, and I quote, "I have learned that despite the constitutional presumption of innocence, the vast majority of criminal defendants are in fact guilty of the crimes with which they are charged. Almost all of my own clients have been guilty. I'm not unique in representing guilty defendants. That is what most defense attorneys do most of the time. The Perry Mason image of the heroic defender of innocent victims of frame-ups or mistaken identification is television fiction. Once I decide to take a case, I have only one agenda. I want to win. I will try by every fair and legal means to get my client off without regard to the consequences. There's an old story about the lawyer who has just won a big case for his client and cables him, "Justice has prevailed." The client fires off a return telegram, "Appeal immediately." The story underlines an important point about the realities of our legal system. Nobody really wants justice. Winning is the only thing to most participants in the criminal justice system. Criminal defendants and their lawyers certainly do not want justice. They want acquittals, or at least short sentences. In quoting Professor Dershowitz, I don't want to suggest we should presume that a man accused of rape is lying any more than we should presume that a female accuser is lying. The whole point of Title IX is that both parties must be treated equally. The question of who is credible is always fraught, and it's crucial that we do everything possible to discover what really happened without bias based on the best available evidence. Accusations of sexual violence seem to make everyone they touch uncomfortable, even bystanders pondering the allegations from afar, because they require us to come down on one side or the other. Do we believe the alleged perpetrator or the alleged victim? It's morally impossible to remain neutral, Judith Herman declares in Trauma and Recovery. The bystander is forced to take sides. It is very tempting, Dr. Herman continues, to take the side of the perpetrator. All the perpetrator asks is that the bystander do nothing. He appeals to the universal desire to see, hear, and speak no evil. In order to escape accountability for his crimes, the perpetrator does everything in his power to promote forgetting. Secrecy and silence are the perpetrator's first line of defense. If secrecy fails, the perpetrator attacks the credibility of his victim. If he cannot silence her absolutely, he tries to make sure that no one listens. To this end, he marshals an impressive array of arguments, from the most blatant denial to the most sophisticated and elegant rationalization. After every atrocity, one can expect the same predictable apologies. It never happened. The victim lies. The victim exaggerates. The victim brought it on herself. And in any case, it is time to forget the past and move on. The more powerful the perpetrator, the greater is his prerogative to name and define reality. And the most completely his arguments prevail. Having to decide who is telling the truth makes us squirm. And the alleged rapist is most often the beneficiary of our discomfort, because all that's required for him to prevail is for us to opt out of deciding. Title IX can't do anything to fix this, but it can make the contest between accuser and accused more equitable. When a rape allegation is adjudicated at a criminal trial, the defendant is granted major advantages right out of the gate. Not only must the prosecution prove his guilt beyond a reasonable doubt, but the defendant is presumed to be innocent, which implicitly tells the jury that his accuser is presumed to be lying. Title IX diminishes these advantages by assigning equal weight to the credibility of the alleged offender and the alleged victim. This makes campus proceedings a lot more likely than criminal proceedings to actually uncover the truth, achieve justice for rape survivors, and prevent sexual offenders from harming other students. Groundbreaking research by Dr. David Lisak into the behavior of sexual offenders makes the prevention aspect of Title IX especially compelling. Dr. Lisak's research, which has been corroborated by subsequent scholars, revealed that most instances of sexual violence are premeditated acts by serial predators, each of whom is likely to commit an average of 6 rapes and numerous other violent crimes. A small number of men, it turns out, are responsible for the majority of sexual assaults in any given community, including university communities. Equally disturbing, these repeat offenders are often regarded by their peers as personable, upstanding members of the community. Sexual predators get away with raping again and again, Lisak says, because most of us are in denial. We're disinclined to believe that someone who's a diligent student or a congenial athlete could also be a serial rapist. But such apparently nice young men do terrible harm to their victims, and it's crucial for campus administrators to regard them as dangerous predators. When campus tribunals fail to hold a sexual predator accountable, it compounds the trauma of the student he has assaulted, but it also does tangible harm to the campus community as a whole. When predators are allowed to rape repeatedly and get away with it, Dr. Lisa told me, their behavior becomes entrenched. It's obsessive. And once this pattern is established, it tends not to be something that just stops. Sexual predators are constantly practicing, constantly testing the boundaries of potential victims. You know how when you talk to an experienced salesperson and after a couple of beers, they'll tell you how you can learn to read people, how you can learn techniques for closing the sale? Sexual predators are pretty much doing the same thing. They are constantly honing their skills, and they get very good at it. They get much better at it than most of us are at detecting it and resisting it. Universities have a moral duty to prevent sexual predators from offending, which admittedly is very difficult. But following the guidance provided by the Dear Colleague letter is a great way to start. The moral duty to shut down campus predation is going to remain even if Betsy DeVos and our predator-in-chief manage to completely neuter Title IX, which is a real likelihood, as you know. The guidance provided by the Dear Colleague letter should still be followed, whatever the Trump administration does to render the statute meaningless. It's just that you don't have to stop just because the law changes. Campuses are free to keep using that guidance. Dr. Lisak's research should further motivate schools to go after campus rapists aggressively. According to Lisak, statistically, the odds that any given rape was committed by a serial offender are around 90%. The research is clear on this. Presently, more than 80% of campus rapes are never even reported. Whenever a student does report a rape, therefore, it is imperative that administrators take the report seriously and treat the matter as if they are going after a repeat offender. Every time a student files a sexual assault grievance, he or she is giving the university a unique opportunity to prevent multiple students from being preyed upon. If administrators decline to pursue the case aggressively, the offender will almost certainly harm more students. Administrators should not be deterred by claims that adjudication of Title IX complaints denies the right of due process to alleged offenders. This is bullshit. Courts have repeatedly ruled that campus disciplinary proceedings don't have to meet the same restrictive standards as criminal proceedings. Universities simply must provide the minimum procedural safeguards required by the 14th Amendment, and most proceedings I'm aware of absolutely do this. Enrollment at Stanford or any other university is not a right, it's a privilege. Colleges and universities are allowed pretty much free rein to determine who they accept as students and who they turn away. Schools are also allowed to establish a code of conduct that every student must follow and are granted broad discretion about how to respond when students violate that code of conduct. Bear in mind, however, that schools are not granted the power to incarcerate students, even when the violation is rape. Nor do schools have the power to compel anyone to register as a sex offender. This, in a nutshell, is why universities don't need to run their disciplinary hearings as if they were criminal trials. University officials, like officials at high schools and elementary schools, must be allowed to identify and expel students who pose a threat to other students, without waiting many months or even years for the criminal justice system to run its course, a course that too often fails to convict individuals who've committed acts of sexual violence or even charge them with a crime. Without question, whenever a student is accused of sexual assault, a university needs to render its judgment with tremendous care, because to be labeled a rapist carries an indelible stigma, and to erroneously determine that a student is responsible for an act of sexual violence when he's actually innocent could cause him lasting harm. There's no denying it. But a university needs to take just as much care not to get it wrong the other way, by incorrectly declaring that a student who has committed rape is innocent. When a rapist is mistakenly exonerated, it incorrectly suggests that the person he raped was lying, unjustly stigmatizing the victim, thus compounding the trauma of being raped. It's easy to forget that the harm done to a rape victim who is disbelieved can be at least as devastating as the harm done to an innocent man who is unjustly accused of rape. And without question, the former happens much, much more often than the latter. There's no comparison. But what if mistakes happen? Isn't it possible that some totally innocent male students might get expelled under Title IX? Yes. In fact, it's inevitable. But it's also inevitable that campus disciplinary panels will continue to get it wrong the other way, too, by failing to hold campus rapists accountable. And universities are likely to err in that direction much more often because so many misconceptions about rape are still so widely held. Regrettably, too many of the campus administrators who establish policies about sexual violence empathize more readily with male students accused of sexual misconduct than with female students who have been victimized. I'd like to believe this misplaced empathy is unconscious and reflective, but remains the unfortunate norm nevertheless. For example of what I'm talking about, all you have to do is look what's going on right now, right here at Stanford University. Last year, Stanford adopted a new process for adjudicating sexual assault cases under Title IX, ostensibly to make the school's disciplinary proceedings more equitable. That's what they said. In reality, the new process is patently unfair to students who allege they've been assaulted. Stanford now has the distinction of being one of the worst universities in the United States for victims of sexual violence, right here, this esteemed institution. There are several serious problems with Stanford's new process. But the biggest problem is that for a student who is claiming assault to prevail, a panel of 3 people selected by the university provost must reach unanimous agreement, which means the alleged victim requires 3 votes to win her claim, while the alleged offender needs only a single vote. On what planet would this be considered equitable? Stanford is one of the most admired universities in the world, justly so, and congratulates itself for being a paragon of innovation and a bastion of noble ideals. How then does the school square its professed values with its new Title IX process, which makes the administration appear much more concerned about protecting the Stanford brand than protecting Stanford students from sexual violence? One of the overarching principles of Title IX is that the competing claims of alleged victims and alleged offenders need to be considered in an absolutely even-handed manner for an equitable resolution to be reached. Yet too many schools, like Stanford, seem to be fixated on the misguided idea that the harm done to a student who's expelled is much more injurious and therefore deserves more consideration than the harm done to a student who is raped. Ergo, a student who is accused of rape deserves more procedural protection than a student who accuses him. About 5 years ago, I learned that a woman in her late 20s, with whom my wife and I have a close relationship, had been raped by a male peer when she was in her mid-teens. A few years later, she was sexually assaulted by a different acquaintance. This time, the perpetrator was a trusted family friend whom I know really well. Didn't know about it at the time. The men who assaulted her didn't just steal her innocence, they poisoned her understanding of who she was. They transformed her into a kind of ghost, trapped forever in the act of being violated. In the wake of these betrayals, my young friend sought relief by focusing obsessively on her career, sometimes working 48 hours or more without a break. She gobbled Adderall to stay awake and guzzled alcohol to fall asleep, following this regimen for years with grim perseverance. It was an unconscious attempt to annihilate herself, she now recognizes, in order to escape the despair that hounded her without respite. I wasn't aware that she'd been assaulted or was so distraught until she ended up at a facility in Arizona that treats trauma and addiction. During the period that preceded her arrival there, she repeatedly found herself engaging in one-night stands with uncaring men. She told me that while she was in treatment, that her therapist explained that her sexual acting out was a reaction to the trauma of being assaulted, what Sigmund Freud called the repetition compulsion, one of the few things that Freud might have gotten right. She was trying to take back control of her life from the men who raped her. It was a heartbreaking effort to make the world safe again. My friend suffered intensely for many years after she was raped. And her misery, she said, was magnified by the stigma attached to the unhealthy compulsions that tyrannized her existence after the assaults. In this regard, she was like many other rape victims. Their self-destructive behaviors are often held up as proof that they are unreliable and morally compromised, or that they deserve to be raped. After my friend told me about what she'd endured, I was angry with myself for being so uninformed, not only about her ordeal, but about non-stranger rape in general. So I resolved to educate myself. I did a lot of reading, and I sought out rape survivors who were willing to share their stories. Writing my most recent book, Missoula, was an outgrowth of this quest. As the scope of my research expanded, I was stunned to discover that many of my acquaintances, and even several women in my own family, had been sexually assaulted by the men they trusted. The more I listened to these women's accounts, the more disturbed I became. I had no idea that rape was so prevalent or could cause such sharp and lasting pain. My ignorance was inexcusable, and it made me ashamed. While researching Missoula, I learned that the most common causes of post-traumatic stress disorder in this day and age are rape and war. Not surprisingly, survivors of sexual assault frequently exhibit the same symptoms as behaviors of survivors of combat, and they exhibit these behaviors much more often than war veterans. These symptoms are flashbacks, insomnia, nightmares, hypervigilance, depression, isolation, suicidal thoughts, outbursts of anger, unrelenting anxiety, an inability to shake the feeling that the world is spinning out of control. The repercussions of severe emotional trauma, whether from war or rape, are typically felt for decades. But there are ways to transcend the trauma. Counseling from a skilled therapist can certainly help, and so can speaking the truth about the unspeakable nature of the harm. By such means, my friend managed to regain her equilibrium and find a measure of peace. A significant part of her healing, she said, came from sharing the excruciating facts of her ordeal with her family and friends after suffering in secret for so long. Rapists rely on the silence of their victims to elude accountability. Simply by recounting their stories and breaking that silence, survivors of sexual assault strike a powerful blow against their assailants. Title IX was enacted in part to give victims incentive to break that silence by offering them with a more reliable way to find justice. Sadly, many victims who have come forward continue to be disbelieved and fail to find justice through Title IX in the courts or anywhere else. But by speaking out, they're likely to encourage other victims to tell their stories too, and may find that they've advanced their own recovery in the bargain. As more and more survivors emerge from the shadows and reveal the pervasiveness of sexual assault, they draw strength from their numbers. This collective fortitude touches all victims, even those too fearful to speak for themselves, by erasing the undeserved sense of shame that is so often born in isolation. Thank you for hearing me out.